5 seconds to go. Start. The claims are entertained and directions issued that would not only be against the tenets of the justice but would negate its ethos, resulting in the law being a casualty culminating in anarchy and lawlessness. The court cannot ignore the law, nor can it overlook the same to confer a right or a claim that does not have legal sanction. Equity cannot be extended, and that too negative to confer a benefit or advantage without legal basis or justification. As regards the compassionate appointment being sought to be claimed as a vested right for appointment, suffice it to say that the said right is not a condition of service of an employee who dies in harness, which must be given to the dependent without any kind of scrutiny or undertaking a process of selection. It is an appointment which is given on proper and strict scrutiny of the various parameters as laid down with an intention to help a family out of a sudden pecuniary financial destitution, to help it get out of the emerging urgent situation where the sole bread earner has expired, leaving them helpless and maybe penniless. Compassionate appointment is therefore provided to bail out a family of the deceased employee facing extreme financial difficulty, and but for the employment the family will not be able to meet the crisis. This shall in any case be subject to the claimant fulfilling the requirements as laid down in the policy, instructions, or rules for such a compassionate appointment. It must be clearly stated here that in a case where there is no policy, instruction, or rule providing for an appointment on compassionate grounds, such an appointment cannot be granted. The very basis and the rationale wherever such policies are framed for compassionate appointment is with an object to grant relief to a family in distress and facing destitution, and thus an exception is culled out to the general rule in favor of the family of the deceased employee. This is resorted to by taking into consideration the services rendered by such employee and the consequent legitimate legal expectations apart from the sudden change in status and affairs of the family because of the unexpected turn of events, that is the loss of the sole bread earner. The purpose, therefore, of such policies is to give immediate succor to the family. When seen in this conspectus, 3 years as has been laid down from the date of death of the employee for putting forth a claim by a dependent, which includes attainment of majority as per the 1999 policy instructions issued by the government of Haryana, cannot be said to be in any case unjustified or illogical, especially when compassionate appointment is not a vested right. In the present case, as is apparent from the record, the appellant attained majority 11 years after the unfortunate death of his father. The claim thus has rightly been rejected by the respondent state. The decisions of the High Court void the impugned judgments, rejecting the claim of the appellant thus cannot be faulted with. The claim of the appellant for appointment on compassionate grounds having been found to be not sustainable, an aspect that has come to light which requires consideration, as has been put forth by the learned counsel for the appellant, is with regard to the grant of ex gratia financial assistance. This is asserted in the light of the fact that the claim of the appellant was pending consideration for compassionate appointment for long with the respondents, and the same had finally been decided on 28th April 2009 by rejecting the same, and that too primarily on the ground that the said claim is time barred. It is further stated that in the impugned order dated 28th April 2009 that there is no provision for providing job under the ex gratia scheme in the 2006 rules. Going by the stand of the respondents, it is apparent that the claim of the appellant was considered under 2006 rules, which were enforced with effect from 1st August 2006. These rules, apart from other aspects, provide for the manner of dealing with the pending cases. Rule 8, which relates to repeal and savings, mentions the earlier prevalent rules, namely the Haryana Compassionate Assistance to the Dependents of the Deceased Government Employee Rules 2005. The first proviso thereto states that the families would have the option to opt for the lump sum ex gratia grant provided in the rules of 2003 or 2005 as the case may be in lieu of the monthly financial assistance provided under the 2006 rules. Therefore, as per these 2006 rules, the claim of dependents of the deceased employee would inure for consideration to ex gratia compensation. The said claim, therefore, as far as the widow of the deceased is concerned, would survive and operate, especially in light of the fact that her son, for whom she had sought an appointment on compassionate grounds, has been found to be ineligible because of he being a minor. A further perusal of the 2003 and 2005 rules would show that the pending cases were to be dealt with under those rules. The admitted factual position is that all through the claim of employment of the appellant was pending with the respondents, and consequently the right of consideration of claim for ex gratia compensation would also subsist. Given an option, the mother of the appellant could have sought the benefit of such compensation had she been informed in time about the non acceptance of her request for employment of her minor son. She was kept waiting for a final decision on the claim till its rejection in 2009. The government of Haryana had taken a conscious decision on 16th March 2011, granting a mercy chance as one-time measure to exercise option for ex gratia compensation. A perusal of the said decision would show that it was a one-time relaxation for applying for ex gratia compensation in old cases pertaining to the claims before 1st August 2006. This was done having regard to the fact that in old cases where the family of the deceased employee could not exercise the option within time due to lack of requisite knowledge or other reasons because of which their dependents could not avail the benefit under the ex gratia scheme being time barred. Such dependents were accordingly given one more chance to give an option. Admittedly, this decision of the government was never brought to the notice of the mother of the appellant. It could not be disputed that no intimation whatsoever had been sent to the widow of the deceased government employee regarding the exercise of such an option. Had she been informed, she could have applied for the grant of ex gratia compensation. The inaction on the part of the state in intimating her of her entitlement to put forth the claim is the reason for she having not opted for it. It would thus be just and reasonable that one opportunity is granted to the widow of the deceased government employee Jayaprakash and the mother of the appellant to make a representation for exercising her option for the grant of lump sum ex gratia compensation. Stop.